Thank you to all those of you who are joining. We'll get started here just momentarily. I'm Mark Herzl, the second vice president of your Foreign Trade Association. Today's event will be recorded with a copy to be made available at a later date. A few housekeeping rules as we get started. We ask that you please mute your phones or your computer mic to eliminate any background noise. Also, please disable your cameras, which I'll be doing in a moment. And then use the chat function for any questions that might arise or be able to be addressed later. Our speaker this morning is Andy Kehagiaras, which is he's a founding member of Roberts Kehagiaras LLP and has 22 years of legal experience with a focus on admiralty, transportation, logistics and warehousing, cargo claims, marine and inland marine insurance. Mr. Kehagiaras has represented U.S. and foreign clients in state, federal, and international litigation and arbitration with an emphasis on the resolution of cargo-related issues, and advises insurance and risk management interests in areas of marine and inland marine, property and casualty, commercial general liability, professional errors and omissions, and offshore captives on issues of coverage, bad faith defense claims, analysis, claims handling, allocation methodologies, risk management, regulatory compliance, and dispute resolution. Roberts Kehagiaras is a longtime member of the Foreign Trade Association and has sponsored and supported many FTA events and is active in other local, regional, and national trade organizations. Andy is an AV-rated attorney, something I had to look up, which signifies an attorney's highest level of professional excellence. He is licensed to practice in California and Michigan, the Ninth Circuit Court of Appeals, and all federal district courts in California, the 10th Circuit, the District of Colorado, and the Court of International Trade. In short, he is well qualified to address us on the subject of force majeure. Mr. Kehagiaras earned his BA with a distinction in economics from the University of Michigan, Dearborn, go Wolverines, JD from Wayne State University Law School, go Warriors, and a Master of Laws in Admiralty from Tulane University School of Law, and their mascot is the Green Waves. So to keep the W alliteration going, we're going to welcome you this morning, Mr. Kehagiaras.
Thank you very much, Mark. I appreciate the kind introduction that I wrote. So that's most generous on your part. To also keep the W streak going here, I just have some introductory, more background material than anything else. Not being an epidemiologist or certainly anything political, but when I was discussing today's presentation with the FTA, I did want to put it off as long as I could, and among the dates that we could do it was the 30th of June. And the significance of the 30th of June is that it is 5 months to the date when the WHO declared the pandemic to be a global health emergency. On January 30th, there were 9,976 cases in 21 countries. And just before I logged on this morning, I just Googled number of COVID cases, and we're now at 10.3 million. So I know that there are debates out there about the measurement and who's doing what and is it political, but nevertheless, I think we'd all accept the proposition that what has happened here has been exponential and is having effects in trade logistics and in the marketplace in general. And that is what I would like to discuss today. Okay, wait a second. I'm sorry, folks. There we go. Now I know how to control my presentation. So again, this was just by way of background, just to remind everyone where we've been and how we got here. The way I want to approach force majeure is to present the subject as a matter of building blocks. Force majeure didn't just come from nowhere, and one of the oldest concepts is the notion of an act of God. And the genesis, well, that's a horrible pun, but the source of an act of God is something that is by natural causes. And I put up a couple of definitions on there. The first one's from the Insurance Risk Management Institute. And you see the commonalities between that definition and the Black's Law Dictionary definition. And for the non-lawyers among us, Black's Law Dictionary is the go-to dictionary. And so the takeaway, the first building block, act of God, is natural causes and without intervention of human agency. So you can't do what lawyers call create the peril. So if there's some intervention by people, then it can't really be an act of God. And that's why typically when we think of act of God, we think of these natural phenomena such as earthquakes and floods. The next building block is interesting. It's impossibility. And the overarching issue here is an inability to perform. Either one is unable to do so, or performance has become extremely burdensome. And again, I put up the Black's Law Dictionary definition, but the bigger takeaway here is that something unexpected has happened. And that unexpected thing was the non-occurrence of that unexpected event was a basic assumption of the contract. And I'll give you an example here in a moment. And the result, again, is that performance has become impracticable. So an easy example is that a homeowner agrees to pay a painter $10,000 to paint her house on July 1st. But the owner's house is burned down on June 30th. So long as there's no fault on the part of the owner, in other words, the owner can't, once again, create the peril, the owner can't burn her own house down. But if we have a situation where, of course, we were assuming the house would be there on July 1st, but if that's happened and it's objectively not the fault of the owner, at this point now, in this example, impossibility is, in its literal sense, what is preventing performance of the contract. Now, originally in the development of the common law, it used to be that it would have to be literally impossible. The house is not there, you can't paint it. But over time, it has evolved into, again, an unduly burdensome and unreasonable imposition on the performance. So far, these two building blocks that I've presented, these, all else being equal, and certainly historically, were not things that one would see in a contract. Now, the next building block on this road toward force majeure is the doctrine of frustration of purpose. Frustration of purpose has nothing to do with the inability to perform. Now, you see that I've highlighted the portion there about, again, the non-occurrence of event is, so it shares that with impossibility. But the focus of frustration of purpose, and while it's related to impossibility and while sometimes both apply, the focus here is that performance has become worthless to one of the parties in the transaction. So, we're counting on something not to happen, and once again, it has. So An easy example here is a buyer has contracted to buy a commercial building for the purpose of generating rental income. While the sale is pending, the city condemns the building. And so the very purpose of the buyer's entry into this contract, which is, of course, to generate rental income, has now been frustrated by an event that the parties to the contract were counting on to not occur. It would be to both parties' benefit, obviously, for the building to not be condemned. The seller gets its money, the buyer gets its building, and can then generate income. The classic example that we all who went to law school learn about is a 1903 case from England. And this had to do with the 1902 coronation of Edward VII. So the high altitude view here is, what's the purpose of renting an apartment on the coronation route? The purpose, of course, is to view the coronation procession. And the key here is that both parties understood that to be the purpose. Now, I highlighted implied condition there in the second bullet point because, again, this is an instance where the contract, this 2-day lease didn't spell out A is renting to B for purposes of the coronation, but when showing the apartment, the landlord makes sure to say, hey, look at this view from this window, it's going to be perfect. And so to the extent that both parties understood the coronation to be the purpose, the court in this case excused performance, excused the obligation of the renter to pay rent. Now, again, the concepts are related, but performance here was not impossible. There was, the renter was able to pay rent, and obviously the landlord was able to rent the premises, but the purpose was no longer in place, and everyone understood that, and that was a turning point in the law. What started out as these common law and equitable principles eventually moved their way into statutory law. And so we have an example under California law in the civil code where, and now with these statutes and some of the contract provisions, you're going to start to see some of the concepts from the building blocks work their way into what's written, whether again in a statute, in a contract. So I highlighted the irresistible superhuman cause. That is act of God language. The statute here goes a little further and talks about acts of public enemies or of this state or of the US, and we'll return to that because that's significant in terms of what's going on now. The last part, the last clause there, unless the parties have expressly agreed to the contrary, that is the statute acknowledging that parties are free to allocate risk as they choose. And again, that's when we eventually get to contractual force majeure clauses. But the law bakes it in and says, look, we're setting the bar, and yet we understand that parties in our free market system can contract but pretty much to anything, so long as it is not illegal. I put up this section from Article 2 of the Uniform Commercial Code, not because I want you to read the fine print, but this is a pervasive law. This is a provision from Article 2 of the Uniform Commercial Code. Article 2 deals with sales of goods. And that's important to remember because the concepts here aren't going to apply to services, whether we're talking about a freight forwarder or a port or a steamship line. And again, that's my background. But what the UCC introduced in this section 2615, And arguably it's just renaming it, but it's the concept of commercial impracticability. And again, this is a reflection of moving away from that literal impossibility to considering what are the commercial implications that this event has imposed upon the parties. And again, the second highlighted portion there, again, you see this, the non-occurrence, which was a basic assumption. So you're starting to see the evolution and the building blocks from the common law having now worked their way into the statutory law. And this section in Article 2 in general, a form of this is in place in 49 states, Louisiana being the exception because it's based on French civil code. The other thing that I highlighted here is in subsection 3, which is a notice requirement. And you're going to see that a lot in contracts, but it's interesting to me that the UCC does put the obligation on the affected seller to provide notice to the buyer. And sometimes, certainly in contracts, and obviously under this legal statute here, giving notice is often an issue in these cases. It's one thing for a force majeure event to occur, or in the parlance here, commercial impracticability to occur. But there could be situations where you're dealing with a faraway buyer where that buyer might not know the conditions on the ground. And so providing notice is part and parcel of being able to avail oneself of commercial impracticability as a means to excuse performance. Because again, one of the other overarching themes of what we've discussed so far and a force majeure is excuse of performance, because otherwise you have a contract and all else being equal, one must perform. So what we're discussing are things that allow the performing party to take time out and not perform and yet not be in breach. So that's the bigger picture. One of the interesting things, at least to lawyers, about the UCC is that it contains comments, and the comments to the law are often very insightful. And there are comments from the folks that put together the UCC, as well as comments from every state. So the first highlight, again, I just want to emphasize that we are seeing an evolution here of the notion of supervening circumstances. The second bullet point is a big one. This is a major point of contention in all kinds of either UCC or contractual litigation. Parties enter into contracts for purposes of we want to achieve certainty, we want to manage risk. There are no guarantees. This second comment here underscores that it's foreseeable that prices of raw materials could increase. So if you produce widgets and you need commodity A to make your widgets, just because the price of commodity A goes up, the comments make clear that that by itself is not going to excuse performance. It would have to be an increase in cost, but it would have to be an increase in cost that is extreme. And the interesting quote there is, to alter the essential nature of performance. What does that mean? And of course, people litigate what that means. But to change the essential character of a contract is, again, a policy decision that state legislatures have made that said, well, no, we need to protect. It's one thing to say, well, commodity A is now going to cost you a little more. Sorry, those are the ups and downs of businesses. But it's quite another thing to say that the essential nature, the performance is now different. It's one thing to squeeze your profit margin. It's another thing to completely put a party upside down in an extreme way. And in that last highlight there, again, you see something that resonates with what's going on right now, with what happened in terms of the shutdown of major sources of supply. That is one of the issues, of course, that we saw starting in February and March, which I will get into here in the upcoming slides. So we've finally gotten to some French words. Force majeure, superior force. I emphasize that it's a creature of contract because there is no force majeure law out there. And I've read a lot of articles in cases in preparing for this, and I often read about so-and-so declared force majeure. Well, unless there's a contract behind that, the declaration doesn't mean anything. There has to be a source. On the subject of preparation, one of the things that I found funny, if I could use that word, was someone made the comment that there's a pandemic of webinars dealing with force majeure. So add me in, but at least I had the foresight of the 5 months and to draw a nice marker in time. And I originally gave a version of this presentation on March 9th in Miami, where they were still having a good time yucking it up. I went to New Orleans for a conference later that week on a date, it was like around the 11th, when there were no cases in Louisiana, which eventually became a hotbed of the pandemic. Again, I call upon the Black's Law Dictionary definition as a good reference point for us. The takeaway here is that you'll notice that this pulls together both the concept of act of God, the natural forces, along with now man-made forces, acts of people, riots, strikes, wars. So you have an expansion of the concept of excuse of performance under force majeure, but by and large, and certainly in the US, that has to be in a contract. This next slide underscores that, where in other jurisdictions, it's different. It can never be implied in English law. Under the law of China, which is, of course, our major trading partner, the opposite is true. One can imply force majeure into a contract. And at least to an extent, if you think back to the civil code slide I put up a few minutes ago, the same is true in California. Now, again, one can't declare force majeure, and the statute is somewhat narrow in its wording, but at least it's there. So one of the things I found interesting about China, and I think is relevant again to our marketplace, to the FTA, is this CCPIT. And this, of course, is an arm of the government of China that, in order to help its exporters, decided that it would allow folks to apply, and upon review of an application, the CCPIT would issue a force majeure certificate. Now, what's the value of that? I mean, certainly from the exporter's point of view, it could hold up that certificate, and in fact, in the next slide, you see one there, and it could say, look, my government has certified that what's going on here, and let's go back to January into February, has so impacted me that under the law of China, I am excused from performance. I am excused from making the export widgets that you were expecting to receive here on the West Coast. And so that was interesting. Again, different system, but an example of a direct intervention by government, which arguably itself could be an active state under a force majeure clause here in the US. And we're going to look at a couple of them. there's a lot of writing up on this slide, and again, I will not read it to you, and but I do want you to take a couple of things away from this example one and the next one. The interesting thing about these two is that a single client had come to me in February, and it was a US corporation that was a subsidiary of a Japanese engine component manufacturer, the factories of which were in China. And this US-based supplier was starting to get a lot of pressure from its buyers here in the US. And they said, well, what do you do? Or what should we do? And my response was, okay, well, let me see your contracts. And so there were three flavors. There was this one, number two, and then there was customers for which there was no written contract. So I had a variety pack here. So the takeaway from number one is that what qualifies as a force majeure event is whatever the governing law says it is. Now, I confess I don't recall what the governing law is, but you can see already that in the US, the answer would be, well, you know, there is no per se definition of force majeure. In China, that could be different. And so this is an example of a clause that is dependent on whatever the governing law, the contract says, applies as between these parties. The other interesting thing about this clause is that it excuses performance of any obligations under the contract. Contrast that to this second example. Let's drop down to B first. B says that financial inability does not qualify as a force majeure event. So putting aside the applicable law, this second clause tells us that, well, you know, if all this is the inability to pay, sorry, you still have to pay. And so in that regard, this says the opposite of the first clause. What's even more interesting to me, and I hadn't seen this in a force majeure clause before this one, is that the seller not only takes the hit of the force majeure event, but if you look in the middle where I've highlighted and require seller, it requires the seller to pay for the price differential of any goods that the seller can't deliver. So in other words, the seller declares a force majeure under this contract. Sorry, I can't perform. And under this contract, okay, seller, you are excused from performance. No problem. I, as the buyer, however, I have the option to go out into the marketplace and to buy substitute goods. And if I have to pay $100 per widget instead of the $50 I was going to pay for you, the seller gets to cover that $50 price differential. And I couldn't believe it when I saw this one. It's very, very onerous, and a good reason to read clauses such as this. This third one differs from your typical clause in that if you look at the second clause, regardless of whether it was foreseeable, so far in whether we're talking common law statutes or most force majeure clauses, the event that happens, you know, the non-occurrence of it has to be, you know, a bedrock principle of the contract. It can't be foreseeable. Well, this gives the parties that much more latitude. So the emphasis here is that one is prevented from performance. So long as this party uses reasonable efforts, even if the event, even if this contingency is foreseeable, the party will still be excused from performance. So this is a little more in my wheelhouse with my maritime law background. Carriage of goods by sea act, you'll see in the first bullet point, does contain an express exemption of the carrier's liability for an act of God. It also contains an express exemption for a quarantine restriction. And so, again, I've never seen a quarantine case in my 20 some odd years of practice, but I have a feeling I probably will see a few this next year. This statute, well, it's from the 1924 Hague Convention, but in the US, this became the law in 1936. Private business has also responded. So in other words, charter parties, which are not subject to Carriage of Goods by Sea Act, also, some of them at least, will provide for this situation. Now, BIMCO is the Baltic and International Maritime Council. So BIMCO is the largest international association of ship owners. 65% of the world's tonnage are members of BIMCO. And so this clause was in response to the Ebola outbreak a few years ago. And the first subclause there vests judgment, reasonable judgment, in either the master of the ship or the owners. They can make a judgment call that if anyone's at risk, they can take certain steps. And 1.2 there goes over some of the steps that are available. It could be that the vessel may not call a port, or it may stay at a certain port. It could be that the vessel will refuse bills of lading. And so that this would create a conflict between the charterer and the owner. The charterer wants to get its goods to market. It could be that the ship owners don't want to risk the crew. They don't want to risk detention of a ship in an affected port. And so they could exercise, again, contractual rights under this charter party. Charter parties often do incorporate the Carriage of Goods by Sea Act, but here you see a very specific virus-inspired, if you will, contractual provision, the purpose of which, again, is to vest discretion and judgment in the ship owning interest, which of course is no surprise, BIMCO being a ship owners association. So that's an example of, at least in the chartering world, the control that asset owners can exercise over the supply chain. Over the past few months, I've heard a lot about blank sailings, and blank sailings are just nothing more than cancellations, just a fancy way of saying canceled voyage. But again, this underscores what we were seeing since March, which was capacity cuts all over the world. And as you can see in the third bullet point there, in that period between March and early June, CMA, the French carrier, had blanked 23 sailings in the process of declaring a force majeure. And again, declaration with reference to its bills of lading, its tariffs, its terms and conditions. So not only were the steamship lines in on it, but ports internationally were themselves declaring force majeure. Ports tend to do business under their own tariffs, their own terms and conditions. So in March, in India, there's a declaration, and part of that declaration is that, we're not going to be responsible for anything, for any charges. And likewise in South Africa, pointing to its trading terms, they declared that they're going to be relieved of any liability. And delays, nope, that's on you. I had an example recently where cargo arrived at the port of Los Angeles. It was an MRI machine that, when you ship those, and the helium and the magnet has to remain at a certain temperature, there's a finite window before the MRI's magnet will boil, or at least the helium boils off. And anticipating this, well, not anticipating the pandemic certainly, but anticipating the tight windows, the importer set up a customs pre-clearance. And so there was, in fact, a 48-hour window from the date of clearance in the Port of LA to get this MRI machine to the buyer so it could plug it in and ensure its continued operation. And because of the capacity cuts here in LA and Long Beach and the labor cuts, it didn't happen. Instead of a 2-day turnaround, it ended up being a 7 or 8 day turnaround. And of course, the claim now is that, well, this freight forwarder was responsible for the delay. Now, this is where some of my insurance background comes into play. The insured, well, the importer took out a policy of first-party cargo insurance. But one of the exclusions to coverage within that policy is delay. And so you combine the delay with perhaps a force majeure or a commercial impracticability event, and you can see how this importer could have to shoulder the burden if its insurance doesn't cover delay, and if the folks in the supply chain can avail themselves of one of these excuses to perform that we've discussed, whether it's a force majeure clause, commercial impracticability, or even impossibility. If there was no capacity, if there were no trucks going into the port, then this in fact could be one of those instances where it might not be literally impossible, but certainly commercially impracticable to move cargo on the 19th and 20th of March of this year. A couple of examples here of 3PLs, and it's along the same lines of what steamship lines have been doing, but again, you start seeing some of the magic words in the language, relieved of contractual obligations, impossible or impracticable. And in this case, it applied to all modes. So this 3PL was telling its customer base, look, whether it's air, ocean, truck, rail, or even customs clearance, there could be delays, and we are relieved because of the epidemic, what was then an epidemic, of performing our obligations to you. This second 3PL was a little more aggressive in its wording, wanted to make sure to cover all of its bases here. But again, a lot of the same language, a disclaimer of liability. And then at the bottom, of course, the highlighted portion there is just to let its customers know that, if there are going to be additional charges here, we will pass those charges on to you. And that's part and parcel, and I'm sure it's in the terms and conditions of this global 3PL to be able to do just that. And that surprises a lot of parties, but at the end of the day, we will not be on the hook, and you will pay for any resulting charges is the takeaway here. One of the things I started doing specifically in preparation for this, as I said, I did give a similar presentation in March. I wanted to see, well, are there lawsuits out there already that deal specifically with the COVID-19 pandemic? And the answer is, of course there are, because this is America and this is how we roll. And this first one, which is in federal court in New York, this is my amusement park case. What I found interesting is that it's a good all-in-one or kitchen sink approach to how to deal with what's going on right now. So the other thing I found interesting about this case is that the plaintiff was a franchisee. The plaintiff went on offense here. So you have a slowdown in the amusement park business, and of course, at some point, a complete shutdown. And the plaintiff had one park open in Texas and had rights to develop 9 or 10 others. But of course, when the cash flow went south, the plaintiff started missing certain payments to the defendant franchisor. And as soon as the defendant said, we're going to terminate this contract, we have the right to do so, that's where the plaintiff went on offense, filed this lawsuit and sought an injunction to prevent the termination. And so, again, why did the plaintiff do this? The plaintiff did this because it wanted a court to declare that the plaintiff was excused from performing the contract. And of course, in this case, performing the contract meant writing checks to the franchisor. And so there was a force majeure clause, and in the complaint, the plaintiff argued force majeure, it argued impossibility, it argued frustration of purpose. If you can't develop a park, or if the one park you have is closed, then you can't generate revenue. And so, I can see the frustration argument. In terms of developing new parks, if construction workers aren't available, if people aren't going, again, I can see the impossibility arguments as well. And of course, force majeure will always depend on what's the language of the force majeure clause. There's never, typically, no one can give you a stock answer of, is this a force majeure event? Well, the answer is always going to be in the force majeure clause. And this could be the lesson of this next April case. So the tenant here missed an April 1st payment, and by April 20th, there was a lawsuit on file in federal court in the Southern District of Florida. You didn't pay rent? Sorry, we're suing you. So here the landlord goes on offense. And in the second bullet point, you see that the landlord at least throws a bone to the tenant and saying, well, yes, well, COVID-19 has posed some challenges. We're hurting too. But you still owe us money. The force majeure clause of our lease doesn't apply. And why is that? And we touched on this in an earlier slide, because the force majeure clause tells us that nothing in here, nothing in this force majeure clause applies to either party's payment of money under this lease. And of course, rent being the primary money due under a lease, and this is where the notion of a deal is a deal. Look, sorry, we're all hurting here, but nevertheless, you owe us rent because the contract says you owe us rent. This is a very interesting case study. So Pier 1 Imports went into Chapter 11 bankruptcy earlier this year. And where I drew this it's not hypothetical, this actually happened. This slide came from a motion filing that Pier 1 made. So Pier 1 at a time was trying to operate these stores. They were doing fairly well with their e-commerce platform, but they wanted to keep the stores going as well. But once it became clear in late March that you were having close or shutdowns in multiple states, California was around the 18th or 19th of that March. It became clear to Pier 1 that, look, we can't do this anymore. So it started going out and trying to get concessions. And, in almost half the cases, it had succeeded. But by the end of March, it said, look, we need to go to the bankruptcy judge and ask for relief from rent. And what I thought was interesting about this case is that force majeure wasn't an option, and so Pier 1 got creative. Pier 1 says that the exercise of each state's police power, California, Texas, wherever, was the equivalent of a taking. So perhaps a lot of you have heard of the concept of taking and the concept of eminent domain. The state shows up and says, yeah, that parcel of land that is part of your, we're going to take that. We're required to pay your highest and best use, but we have the right in the name of eminent domain. So this is a slightly modified version of that. And there can be, there's an actual taking, an actual eminent domain, or there could be a regulatory taking. And that's the argument that Pier 1 made here. And citing to some Supreme Court cases, Pier 1 says, you have regulated us to such an extent that you have rendered our commercial use of these retail locations, and they use the word impracticable. So again, these words keep appearing. You have essentially deprived us of the right to operate. And so now keep in mind, Pier 1 is making these arguments to the bankruptcy judge that's overseeing the reorganization, the purpose of which is to have Pier 1 emerge in a reorganized state and to provide for an orderly and equitable allocation of payments to the creditors. And it did also make the impossibility and frustration of purpose arguments, which again, you can see here similar to the amusement park. You can't operate the amusement park no more than you can operate the local Pier 1 location. And the judge in this case, the other examples I gave you were pending, but here there was a ruling, and the court did grant Pier 1 relief from making rent payments. Again, it excused Pier 1's contractual obligation to pay rent because Pier 1 said, we've called these other locations and, some say they might agree. We don't really know. Judge, we need you to step in. We're already in the course of this reorg bankruptcy. We need an orderly disposition. You have the power to do this. Step in and help us out and help everybody out. And sure enough, the court stepped in, granted the motion, and permitted these guys to suspend rent payments. I welcome any questions that anyone may have. I confess that in getting on a roll here, I have not been checking my feed of any questions that may have come in over the chat. So I will do that now. No questions so far, but I am happy to field any that anyone may have. And I thank you all for attending very much.
Thank you very much, Andy. Very interesting, very appropriate in this time, and certainly thank you for sharing your wisdom and your experience in this very detailed area of the law as we move forward in this brave new world. So. Don't yet see any questions. I guess I had one, if you're still available. Do you have any examples of sort of false or inadequate force majeure contract language, or any examples of that?
So one of the things that has tripped up parties to contracts with force majeure clauses, I tend to see two kinds, and these are very broad categories. There are, think about my last hypothetical that was very, very broad, and broad to the point of saying, pretty much anything that occurs that's beyond the party's reasonable control could qualify as a force majeure event. Now, the other kind of force majeure clause one might see is what I call the laundry list variety, that will say force majeure clauses are defined as strikes, riots, earthquakes, tornadoes. And where the subtlety there is one could create a laundry list and leave out certain contingencies. The way parties deal with that, some laundry list clauses will say unforeseen events without the intervention of either party's agency or fault, including the following. And so there might be a sample list. And then you'll see something like at the end of that, comma, or similar events. So those clauses will try to include in, a catch-all category. But sometimes when that catch-all language is missing and there's just a finite group, let's say there are 10 events on there, and let's say that pandemic isn't one of them. If the wording is such that it says force majeure means the following, 1 through 10, well, then as a matter of strict contractual interpretation, pandemic, because it is not 1 through 10, is not a force majeure event. And that's where, court will step up and say, look, under our system of, private right to contract and the sanctity of that process, courts will not rewrite the parties' contracts. Courts assume that the parties intended the contracts to read as they are stated. And so if what is written is unambiguous, and if it says force majeure event equals 1 through 10, we're not going to add number 11. Sorry. And if, let's say, if this hypothetical were not in California, where maybe one can avail oneself to either that civil code section, or perhaps if it's a contract for the sale of goods to the UCC, you could be stuck inadvertently. So you could think that, should fall within those 10 things. But if it doesn't, and if your contract is written in such a way, and if you're in the wrong jurisdiction, then yes, that's a situation where there could be a shortfall. And I have seen this a lot lately, where contracts are flowing around back and forth, and invariably you see somebody in Microsoft, red line format, stick the word pandemic in there if it wasn't before. Even if there is a catch-all category, some parties would rather see it on the page and not take the chance that a court will say, oh, that is a like event or a similar event. And so the less one leaves the chance in the contractual wording, the better off one will be.
Well, thank you for your very expert review of this thing, and I think the lesson is certainly have your contracts reviewed by a qualified attorney. And Andy, you've certainly shown us you have those qualifications and those examples that you've shown us as to how we can avoid getting caught in some of those situations. So thank you again. Thank you to all who attended our seminar today. It is recorded and will be available at some date in the very near future for you to review. So I'll wish you a good day. And again, thank you again for joining us here today.
It's my pleasure. Thank you very much, everyone.
Thanks.